I rise in response to my esteemed colleague from Colorado's comments about my Amendment 753. And I would say this first. My amendment does not provide immunity to terrorists. What my amendment does is treats terrorists as they should be. We're at war, and under the laws of war, traditionally, we have tried people in military commissions, military tribunals, and those individuals that my colleague from Colorado cited, including the Umar Farouk Abdulmutallab, could be held accountable in a military commission, because our priority has to be, when we are at war, to gather intelligence, to protect our country, and not where we should prosecute in our Article III courts, which I have great confidence in. I served as Attorney General of our state and believe very much in our Article III court system. In light of the recent comments here on the floor, I feel compelled to point out some of the facts that I think are important for the American people to know. On October 12th, Umar Farouk Abdulmutallab pleaded guilty in the U.S. District Court in Detroit, and that case has been cited by not only the senator from Colorado, but by the senator from Maryland and the senator from Illinois as a shining example that, and our Attorney General has cited it as well, as the ultimate and final vindication of the use of our civilian courts for the trial of enemy combatants. I think we need to review who exactly Abdulmutallab is. He's no common criminal. We're not talking about people who have robbed liquor stores or who are Americans who have committed criminal acts in this country. He's the Nigerian man who tried to detonate plastic explosives hidden in his underwear while on board Northwest Airlines Flight 253 to Detroit on December 25th of 2009. Al-Qaeda in the Arabian Peninsula supplied him with the bomb and trained him how to do it. He was subsequently charged in federal court with 8 counts, including the attempted use of a weapon of mass destruction and attempted murder of 290 Americans. The underwear bomber pleaded guilty at trial, telling a surprised courtroom on the second day of his trial that the failed attack was in retaliation for the killing of Muslims worldwide. This has been cited as the final vindication for civilian trials, and I think it's important to mention 3 points about this case. First of all, the presumption seems to be that the civilian court system should have the primary responsibility for questioning, trying, and ultimately detaining foreign enemy combatants with whom the United States is in a declared war with. That's not been the rule in prior conflicts. We are treating this conflict differently than we have treated other conflicts where our enemies have been tried in military commissions. First point. Second, in my view, the administration's eagerness to appease the ACLU by trying enemy combatants in civilian courts misses the whole point about detention in the time of war. When we're at war, we detain and interrogate enemy combatants according to the laws of war to glean valuable intelligence that will help prevent future attacks, save American lives, and help us capture other enemy combatants. Al-Qaeda was at war with the United States long before our country recognized or strongly reacted to this threat. We remain at war with Al-Qaeda, and when we put enemy combatants in our civilian court system, we are focusing on prosecution, and we potentially miss important opportunities to gather information to prevent future attacks. In Abdulmutallab's case, the administration read him his Miranda rights after 50 minutes of questioning. In my view, this jeopardized valuable intelligence, and I know that my colleagues on the other side of the aisle have said, well, eventually he spoke and he gave us lots of information. But why would we put information in jeopardy? Why would we read terrorists' Miranda rights? Because I, as a prosecutor, have never heard a law enforcement official tell me that Miranda rights are a helpful information gathering tool, but that seems to be the position that I'm hearing today. This jeopardized intelligence was clearly unnecessary, and in this case, the fact that we didn't have to rely on a confession, this was a case where we caught the underwear bomber red-handed, So even if we were to have treated him in a military commission and had not given him Miranda rights, had gathered intelligence for as long as we could have, we still would have had him red-handed, because the passengers on that flight saw him. He was caught with the explosives in hand. This was never a case about a guilty plea. The essential question is whether we got the most information possible from a terrorist who was trying to attack Americans and our allies. Again, I want to reiterate, I'm a strong believer in our civilian court system, but I want to point out some of the downsides to using our civilian court system: the costs of security, the cause of civic disruption in the area, the risk of compromising classified information, and the risk of eventual release of these combatants. I've heard some of my colleagues cite the case of Zacarias Moussaoui, who was a member of Al-Qaeda who was involved in the 9/11 attacks, and his involvement spanned nearly a decade, and his case was finally resolved only last year. These proceedings cost millions of dollars and caused substantial civic disruption. For example, the federal courthouse in Alexandria, Virginia was described as an armed camp with heavily armed guards, rooftop snipers, bomb-sniffing dogs, blocked streets, and identification checks. If we had tried him at Guantanamo Bay in the military commission there, these security concerns would have been accounted for. Moussaoui also mocked 9/11 victims and used the civilian trial as a platform to spew terrorist propaganda. All of these negative side effects of trying a terrorist in a civilian court would have been eliminated or significantly mitigated if he had been detained in military custody and if tried before a military commission. In the case of Omar Abdul Rahman, commonly known as the Blind Sheikh, which has also been cited here today, the civilian trial provided intelligence to Osama bin Laden. So when I hear that case cited as a success, the first thing that comes to my mind, if intelligence was provided to Osama bin Laden, how is that a success when our #1 focus should be on protecting the American people? And that has to be the distinction between trying enemy combatants in a time of war and the very important purpose of our civilian court system. In the case of the Blind Sheikh, according to Michael Mukasey, the former Attorney General, in the course of the prosecuting Omar Abdul Rahman, the government was compelled, as it is in all cases, to charge a conspiracy charge and to turn over a list of unindicted co-conspirators to the defendants. Within 10 days, a copy of that list of unindicted co-conspirators reached bin Laden in Khartoum. The notion that a list, because you had to do it according to our civilian court system, where notice requirements are very important, where generally our court systems are open, would be provided to Osama bin Laden, in my view, is unacceptable, a risk we could have avoided. Civilian trials of enemy combatants have provided a treasure trove of information to terrorists, and I think those risks have been very discounted by my esteemed colleagues who have come to the floor to oppose my amendment. According to open source reporting, the cost of disclosing information unwisely became clear after the New York trials of bin Laden associates for the 1998 bombings of U.S. embassies in Africa. Some of the evidence indicated that the National Security Agency, the U.S. Foreign Eavesdropping Organization, had intercepted cell phone conversations. Shortly thereafter, bin Laden's organization stopped using cell phones to discuss sensitive operational details. It's also important to note that the record of trying enemy combatants in civilian courts is not as good as it's been made out to be. The administration elevates the so-called underwear bomber case as definitive, but I haven't heard a lot on this floor about Ahmed Gilani, who was charged with a total of 284 counts, including 200+ counts of murder and 1 count of conspiracy in the 1998 bombings of the U.S. embassies in Tanzania and Kenya. The bombings killed 224 people, including 12 Americans. He also spent time as Osama bin Laden's bodyguard. He was tried in the U.S. District Court for the Southern District of New York. The Department of Justice directed the U.S. Attorney not to seek the death penalty. At trial, the presiding justice excluded from evidence the testimony of a key witness, and on November 17th of 2010, a jury, after this evidence was excluded, a jury found Gilani only guilty of one count of a conspiracy and acquitted him of all 284 other charges. Proponents of civilian trials, such as Attorney General Holder, want to criminalize the war, but they fail to cite these cases where the civilian court system leaked classified information to terrorists or the results because of excluded evidence. Civilian trials for enemy combatants incur tremendous costs, cause civic disruption. That is why the administration itself has reversed its position on trying Khalid Sheikh Mohammed in New York City. If the Obama administration is willing to kill enemy combatants without due process, why is it so against placing these same enemy combatants in military custody and treating them under the law of war and detaining them that way and trying them in military commissions? I think the answer is clear. Unfortunately, I am concerned that it's a political decision rather than putting foremost gathering intelligence to protect the American people and treating these enemy combatants as who they are, enemies of our country. I would urge my colleagues to support my amendment. In my view, beyond the policy reasons for not trying enemy combatants in civilian courts, we should ask ourselves, why should we bring foreign terrorists to the United States and give them the legal protections reserved for U.S. citizens and secured by those who have fought and died for those rights? Why do these people deserve access to our American court system? They are our enemies. In the civilian court system, there are rights guaranteed, such as Miranda rights and speedy presentment, that should not be extended. We need to prioritize protecting our country. I think the American people will agree with me when I say that no terrorist should ever hear the words, "You have the right to remain silent." Thank you, Mr. President.